This lecture will serve as a brief introduction to some of the controversies related to the First Amendment's guarantee of freedom of speech that you may encounter or may be relevant to you as a public manager. And in this lecture, we're going to be briefly discussing 3 issues, and this truly is brief. I've actually taught an entire 15-week course on freedom of speech issues, and will probably take about 15 minutes. But what we'll be talking about is compelled disclosure, which has recently become quite significant, semi-public forums and viewpoint discrimination, and employee speech rights. So first, let's talk about compelled disclosure, because recently the Supreme Court has decided 3 very interesting cases that public managers would be interested in related to compelled disclosure. And this is important because the First Amendment includes the right not to speak. And this is something we've talked a little bit about before, but we've talked about it in terms of the Fourth Amendment. We talked about how agencies will often require institutions, businesses, and others to submit reports and to provide other information that might incriminate them. And so while that might violate the Fourth Amendment, it's also possible it could violate the First Amendment, because the First Amendment does include the right not to speak. And it also includes the right not to be forced to say something that you disagree with. So you have the right to remain silent, and of course the government can't force you to say something that you disagree with. But agencies often compel speech. And so some kinds of compelled speech are permitted, So what am I talking about with regard to compelled speech? Well, for example, mandatory student fees for student publications. Many universities obviously have student fees, and sometimes those student fees support student publications, and some students may object to some of the content in some of the publications that their fees are supporting, but the court has said that this kind of speech is permitted because of the need for a vigorous engaging in ideas at the university. They're also permitted to charge mandatory fees on ads for agricultural products. So the government can have producers of agricultural products pay them money to purchase ads for the entire industry. This kind of fee is permitted. Warnings on alcohol, tobacco, and actually food labeling generally. This is compelled speech that is permitted. Alcohol and tobacco companies don't want to remind you of how deadly their products are, and yet the courts have said that they can do that. More recently, this is interesting, cable systems have to carry local stations, according to the court, but one thing that has not yet been settled is whether or not internet companies must do the same. That's the concept of net neutrality, but certainly one would think that the logic of the cable system's decision would apply to the internet as well. And the FCC fairness doctrine, for example, the FCC, once upon a time, it doesn't do that anymore, required TV stations to present both sides of an issue, even if they didn't want to present both sides of an issue. So these are some examples. We mentioned net neutrality. Abortion disclosure requirements. So a doctor can be forced to talk about certain things related to abortion with their clients that they might not have wanted to do. What kinds of compelled speech are not permitted? Well, New Hampshire had a slogan on their driver's licenses that says, "Live free or die," and somebody covered it up with a piece of tape because they didn't like that slogan, and the court said that they had the right to not have that slogan on their driver's license. Students can't be compelled to salute the flag. Newspapers can't be required to publish an ad or any specific thing. And so this is interesting as well. Many conservatives now say that YouTube and Twitter are engaged in censorship because they sometimes remove right-wing commentators. This is not a problem for the First Amendment because the First Amendment only applies to the government. It doesn't apply to private institutions like newspapers, YouTube, and Twitter. So they cannot be required to print or publish something that they don't want to do. Now, in the last couple of years, the Supreme Court has decided 3 very interesting cases related to compelled speech. And again, as with most things in this course, this is not neutral, it's all ideological, and all 3 of these cases were decided by a 5-4 decision, and all 3 of them were decided in a conservative direction. The first is one you've probably heard of, Masterpiece Cake Shop v. the Colorado Civil Rights Commission. And this was the case in which, of course, a baker refused to create a craft cake for a gay wedding. And although this case was largely portrayed as being about religious freedom, because of course his objection was on religious grounds, in fact the Supreme Court decided it as a free speech case, and they argued that a artisan cake is a work of art which is a form of speech, and therefore the government could not force him to say something that he didn't want to say. In California, we've already heard in this class, of course, about the Janus v. Asks Me case, in which the court decided that it violated the First Amendment to require employees to provide any financial support to unions whatsoever, even if that money was only going to support collective bargaining. And again, this was a free speech issue because the court said that asking for a raise, when a public employee does that, that would require tax dollars to be spent on their salary rather than something else. Therefore, their speech is inherently political, and as a result, nobody can be forced to support it. Finally, from California, National Institute of Family and Life Advocates v. Becerra. And this is sort of interesting, and many people think it's inconsistent because we've already seen that the court has upheld requirements that doctors share information about abortions with their patients. But in this case, you have clinics like this crisis pregnancy center that disguise themselves as abortion clinics, but in fact they are not abortion clinics. And when women come in to obtain abortions, the employees try to do everything they can to dissuade them. California passed a law that required these kinds of clinics to make clear, to post a sign, making clear that they did not offer abortions and providing information for where the clients could go to get abortion information if they wished. The United States Supreme Court in a 5-4 decision said that this kind of regulation was a violation of the Free Speech Clause. So while states can force doctors to communicate critical information about abortion, apparently they cannot force clinics that are fraudulently disguising themselves as abortion clinics to reveal their true nature. This is significant because all 3 of these cases were decided in the same term. All of them were decided by a 5-4 vote, and they may suggest a trend because most governmental regulations that compel speech, of course, are liberal. Most governmental regulations in general are considered liberal, and so I can see in the future the court using this doctrine to strike down a range of regulations that are promulgated by states and the federal government. So I also want to talk about viewpoint discrimination and the concept of semi-public forums. Viewpoint discrimination is a fundamental concept in the law of free speech. And what this means is that the government cannot restrict speech on the basis of the viewpoint that's being expressed. Now, oftentimes, government can regulate speech. For example, the government is allowed to impose what we call time, place, and manner restrictions. There are some places at some times where speech just isn't permitted. For example, large displays of protests near hospitals can be banned. But even when speech can be regulated or banned, it can't be regulated or banned on the basis of the viewpoint that's being expressed. So, for example, a hospital could ban all protests, within 50 feet, but they couldn't ban only anti-abortion protests because that would be restricting the speech on the basis of its viewpoint. So that's important. Now, the interesting thing is, oftentimes public agencies will get involved, though, in these kinds of disputes because they create what the court have called semi-public forums. Public forums are traditional places in society where free speech has generally been allowed. So public forums typically are places like parks and sidewalks and places that have historically for hundreds of years been recognized as places where people are free to speak. But the government will sometimes create spaces for the expression of a message that might not otherwise exist. And when the government creates a space for expression, this is a semi-public forum to which the First Amendment applies. What am I talking about with regard to a semi-public forum? Well, probably the most obvious example would be transit agencies that sell advertising. So BART or the VTA, they sell advertising, and frequently they run into disputes over the contents of the ads. Individuals will want to run, for example, very graphic anti-abortion ads. Ads that are in support or opposition to Israel tend to be very, very controversial and often provoke lawsuits and anger. And so one very interesting case that was decided by the Supreme Court on this issue is Walker v. Texas Division, Son of Confederate Veterans. And this is a classic example of a semi-public forum because the state of Texas, as many other states, allow groups to propose and create personalized license plates, or themed license plates, I should say. Groups in Texas could submit designs to the state, and if they were approved, then they would become available for citizens to purchase. In this case, the Son of Confederate Veterans, a group, obviously, of individuals who were dedicated to promoting the Confederacy, they proposed this design on a license plate, and the state of Texas turned them down, saying that they thought it would just be too controversial. This case made it to the United States Supreme Court, and the court upheld they upheld the decision of the state of Texas to deny this particular license plate. The court said that this license plate was not a semi-public forum, but rather that it was governmental speech. And that's an important concept because although the government does have to be neutral when it creates a public forum, it doesn't have to be neutral when the government itself speaks. So this is an important concept. If the government is speaking, then it does not have to be viewpoint neutral. So if a governor of a state, or if the president is talking, or if a memo comes out, or if the state simply wants to run advertising, if the government is speaking, it doesn't have to be neutral. It can take a stand. But when the government is providing a forum for others to speak, then it does have to be viewpoint neutral. Now, in the Walker decision, of course, the court decided that a license plate was indeed governmental speech. But the dissent argued, and I actually think the dissent was right in this case, although of course I'm not a fan of the Confederacy, but the dissent in this case argued that no one would think that a personalized license plate is governmental speech. In fact, in Texas, one of the license plates you can purchase has to do with delicious hamburgers. And the court said, you know, when you're riding down the street and you see somebody's personalized license plate, you don't assume that the government's trying to communicate that to you. You assume that it's the driver that's trying to communicate that to you. And if that's the case, then the driver's license is a semi-public forum that they can't impose viewpoint discrimination on. But again, that's not what the majority said, and as a result, states are permitted to regulate the kinds of license plates they issue. But this is interesting, of course, because there was another case having to do with the Adopt a Highway program, and this one never made it to the United States Supreme Court. But, of course, you're familiar with the Adopt a Highway program, and in this particular case, the Ku Klux Klan in the state of Georgia wanted to adopt a highway, and the state of Georgia said no. The Ku Klux Klan sued. This went to a court of appeals, and the court of appeals actually decided in favor of the Ku Klux Klan. Now, how this is different from license plates, I could not tell you, but nevertheless, if you go to Georgia now, you can see KKK Adopt a Highway signs. Finally, I want to return briefly to the concept of employee free speech rights. What speech rights do you have as an employee? Now, this is something we've already discussed in another context, and you already know that the First Amendment does apply to government employees just like it applies to anybody else, but it doesn't apply to you as employees. It only applies to you as private citizens. So in fact, the First Amendment doesn't really give you any additional rights that a regular person doesn't have. You already know that speech on the job is simply not protected. We read the case of Garcetti v. Ceballos, in which the court clarified that. However, one really important issue related to this is, what about whistleblowers? What about those individuals who are bringing to light bad conditions in their agency? And in fact, in Garcetti v. Ceballos, Ceballos himself was a whistleblower, and so that case certainly suggests that whistleblowers don't have a whole lot of protection. So the question is, are whistleblowers protected? Well, they are not protected at all by the First Amendment, because of course, if you're, making speech about your job, then you're probably not protected by the First Amendment. However, that doesn't mean whistleblowers aren't protected. They are. They're protected by statute. There's a federal law, the Whistleblower Protection Act of 1989, that is supposed to protect both the identity of whistleblowers and to protect them from retaliation. And California has a similar law, the California Whistleblower Protection Act, that applies to you, public managers. And that is codified in Section 1102.5 of the California Labor Code. So this sounds all well and good, and the Whistleblower Protection Act protects you if you report violations of a law or regulation, if you report gross mismanagement, or a gross waste of funds, or an abuse of authority. Or you can also report a substantial danger to public health or safety. Now, all of these are good things. One would think the public would want to know about these, and so this is a good thing that the Whistleblower Protection Act, at least in theory, protects these individuals. Unfortunately, of course, as with everything in the Trump administration, these norms are breaking down because, of course, the whole Ukraine impeachment saga was set in motion by a whistleblower who read the transcript of President Trump's conversation with the president of Ukraine and thought it was inappropriate, and so blew the whistle. And of course, President Trump and his allies spent months and months attacking the whistleblower, trying to reveal their name, in fact, revealing their name in contradiction to federal law. And what happened? Of course, absolutely nothing. So, of course, like every other law, the Whistleblower Protection Act depends on those in power faithfully enforcing it, and of course that's something that can't be taken for granted anymore at the federal level. Now, if you engage in speech, you can be fired if that speech creates a disruption in your workplace. So this is really important to keep in mind. And this again is related to the Garcetti v. Ceballos case, because employers have a right to have a harmonious working place. And so here are just some factors. I took these straight from the law, but speech can be punished if it interferes with the employee's responsibilities, if it interferes with the working relationship between the speaker and those at whom the criticism is directed. And there are other factors, of course, whether it undermines their ability to be disciplined, whether it compromises the loyalty and confidence of their coworkers, and so on and so forth. So your speech rights only extend as far as they do not disrupt the workings of your agency, unless, of course, it's a whistleblower complaint, in which it should be protected by law. And at the state level, it certainly is, and one presumes that after Donald Trump leaves office, perhaps things will return to normal at the federal level as well.